Welcome back, law students. If you've got an international law exam right around the corner, well, you are in exactly the right place. Think of this as your ultimate comprehensive explainer on state recognition. Over the next few minutes, we're going to break down the exact definitions, the fundamental theories, and the crucial landmark case laws you absolutely need to know to ace your upcoming test. I'm going to give you the structure, the precise details, and the high-yield exam tips you need to write a top-tier essay. Let's get into it.
Here is our roadmap for today's explainer. 1. What is state recognition? 2. Two theories of recognition. 3. Internal and external effects. 4. De facto versus de jure. 5. Landmark case law examples. And 6. Final exam takeaways.
Okay, let's dive right into Section 1. What exactly is state recognition?
Starting right at the foundation of international law, if you want to write a knockout opening for your exam essay, you need a highly precise definition. So, according to Professor L. Oppenheim, recognizing a state isn't just some polite diplomatic high five or a friendly wave across borders. No, it's a formal declaration. By recognizing a new state, an existing state is legally confirming that this new entity fulfills the necessary conditions of statehood. This act is essentially a legal bridge. It profoundly transforms a new entity's status from a mere political fact on the ground into a legitimate, recognized subject of international law. And that grants it some profound legal rights.
Moving on to Section 2, the two theories of recognition.
Now that we know what it is, how exactly does this recognition come to legally exist? You're going to want to pay attention here, because this is a classic high-yield exam question that professors absolutely love to test. There are two competing schools of thought, and distinguishing between them is the perfect way to elevate your legal essay. First up, we have the constitutive theory. Supported by scholars like Oppenheim, this theory argues that the act of recognition actually creates or constitutes the legal personality of the state. Under this view, an unrecognized entity basically has zero rights under international law. It relies entirely on the choice of other states to grant it life. Think of the sea. It creates the state. On the flip side, we have the declaratory or evidentiary theory. This school argues that a state exists as a pure matter of fact the moment it meets objective criteria, having a population, territory, and government. Here, recognition doesn't create the state, it merely declares or admits an already existing fact. Think of the D. It merely describes an already existing fact.
All right, Section 3, internal and external effects.
Now, what's really interesting about this is that once recognition actually happens, regardless of which theory you personally subscribe to, the legal consequences spring into action on two distinct planes, inside national courts and out on the global stage. Let's look at the internal or municipal legal effects first. It's fascinating how an unrecognized state is essentially legally paralyzed in foreign domestic courts until these specific rights unlock. But once recognized, boom, a state gains locus standi. That's the legal right to bring a civil suit to protect its interests. It also gains sovereign immunity, meaning the state and its head of state absolutely cannot be sued or arrested without their consent. Furthermore, domestic courts must now treat the recognized state's internal laws, decrees, and even things like marriages as legally valid. And finally, they get the legal right to claim and transfer public assets and property located within the recognizing country's borders.
Then we have the international plane, where recognition effectively hands a new state the keys to the global community. They gain the right of legation, which is just a fancy way of saying they have the capacity to exchange formal ambassadors and set up embassies. They also get treaty-making capacity, allowing them to sign binding bilateral or multilateral agreements. But, as we know, with rights come duties. The recognized state now assumes full international responsibility for any wrongs or treaty breaches. And lastly, it paves the way for membership in international bodies like the United Nations.
Section 4, de facto versus de jure.
Listen up, because we've arrived at what is arguably the single most critical distinction you need to memorize for your exam, the difference between provisional control and permanent legal right. States often grant recognition in two stages. De facto is a temporary, conditional recognition based on who has provisional control on the ground. De jure, however, is permanent, absolute recognition of a legal right to rule. So the crucial point is how these two differ across four key legal dimensions. For diplomatic representation, a de facto government is restricted to just trade agents, while a de jure government can exchange full ambassadors. When it comes to treaties, de facto handles temporary or administrative agreements, while de jure handles comprehensive political treaties. Succession, and this one is massive for exams, guys. A de facto government cannot claim state assets abroad if a competing de jure government still exists. And finally, revocability. De facto is provisional. It can be withdrawn if the government loses physical control. De jure, that is permanent and cannot be revoked.
Which brings us to Section 5, Landmark Case Law Examples. Okay, let's get into the real meat of any law exam, the case law. Because applying these specific historical facts to the legal rules we just covered is exactly what scores you those top points. We're going to look at 3 landmark cases that test these exact boundaries. Our first one is Luther v. James Sagor and Company. Let's trace the strict timeline here. In 1917, during the Bolshevik Revolution, the new Soviet government confiscated a Russian company's timber mill without compensation. The Soviet government then turned around and sold that very same timber to a UK company. Naturally, the original Russian owners sued in British courts, arguing that the confiscation was illegal simply because the UK didn't recognize the Soviet government. However, and here's the twist, right while the appeal was pending, the UK government officially granted de facto recognition to the Soviet government.
Here is an explicit exam tip for you. You need to know this rule of law inside and out. The British Court of Appeal held that for internal domestic laws like a decree to confiscate property, there's practically no substantial difference between de facto and de jure recognition. Because the UK had granted de facto recognition, the domestic courts were forced to validate the Soviet government's internal acts. Furthermore, and this is huge, it applied retroactively, dating all the way back to when the government actually took power. So the UK company actually got to keep the timber.
Case number 2, Bank of Ethiopia versus National Bank of Egypt and Ligori. Let's trace the steps on this one. In 1935, Italy invaded Ethiopia. The Emperor of Ethiopia fled to London, but the UK continued to recognize him as the de jure ruler. However, the UK simultaneously recognized the invading Italian forces as the de facto authority simply because they had actual physical control of the territory. The Italian authorities then went ahead and passed local laws dissolving the Bank of Ethiopia. So the exiled de jure emperor tried to sue in British courts to stop this dissolution.
Well, the court ruled against the emperor, and this brilliantly illustrates our core concept. The operational realities on the ground completely trump the structural rights of a powerless, exiled sovereign. The court decided that because Italy had de facto control and was recognized as such, its local administrative laws regarding the bank were binding. When it comes to day-to-day internal administration, the de facto ruler holds all the cards.
Now, our final case introduces a really brilliant nuance. Civil Air Transport, Inc., the Central Air Transport Corporation. Picture this timeline carefully. In 1949, the People's Republic of China, the PRC, is established, and the nationalist government flees to Taiwan. Shortly after fleeing, but crucially while still recognized as the de jure government by the UK, the nationalist government lawfully sells its state-owned aircraft located in Hong Kong to an American company. After this sale happens, the UK switches its de jure recognition over to the PRC. The PRC then sues, claiming that since recognition is retroactive, the planes belong to them, and the sale by the nationalists was totally invalid.
Drop this into your exam to really show mastery of the subject. The court held that retroactivity has strict limits. Yes, recognition is generally retroactive, but it absolutely cannot be used to invalidate lawful external property transactions made by a previously recognized de jure government before its downfall. Because the nationalist government was recognized as de jure at the exact time of the sale, and the property was outside the war zone in Hong Kong, the sale to the American company was perfectly valid. Finally, Section 6, Final Exam Takeaways. We've covered the definitions, the theories, the specific distinctions, and 3 major pieces of case law. Let's bring it all together to consolidate your memory right before test day and see how this builds into your final conclusion. First, remember that recognition is the bridge that transforms raw political facts into legally enforceable international rights. Second, confidently contrast the constitutive and declaratory theories right in your introduction. Third, rigorously apply the matrix distinguishing provisional de facto recognition from absolute de jure recognition. And finally, use the case law to prove your points. Luther shows that retroactivity validates internal acts. Bank of Ethiopia shows de facto control trumps displaced de jure rulers internally, but Civil Air Transport proves retroactivity always respects prior lawful external transfers.
I'm going to leave you with a provocative thought. International law isn't just dusty history, it's happening right now. If a sudden regime change happened tomorrow in a major global superpower and competing factions claimed leadership, how would these exact historical precedents we just discussed determine who gets control over billions of dollars in international bank accounts? Think about the timeline of recognition, where the assets are actually located, and who has physical control on the ground. Keep that question in mind as you study, and you are absolutely going to crush your exam. Thanks for joining me for this explainer, and best of luck.